What's up, people, and welcome to another show. And I told you we're gonna have some episodes that are done at night, and yes, it's dark because this is when I have time now. But today's episode is brought to us again by Cedric. Appreciate you, bro. Keep supporting. I appreciate it because we're gonna keep putting it for shows. All right, but today I want to talk about the recent Supreme Court case where it spoke about retaliatory police arrests. They decided it as a First Amendment case because of the whole instance of free speech and yada yada yada. And the case itself is Neves v. Bartlett, 587 U.S. 2019. And the whole crux of any case, whether you are the defendant or you are the accuser, when you're dealing with police, their job begins and ends with probable cause. Probable cause should generally defeat a retaliatory arrest claim brought under the First Amendment unless officers, under the circumstances, would typically exercise their discretion not to make an arrest. Because you've been hearing me say a lot lately, exercising officer discretion. You also heard about me speaking when an officer makes an arrest through a misapprehension of law. Because again, loss of qualified immunity comes from ignorance or them acting in a willful manner. But if it is against federal law, it is a violation of your civil rights, which means they are waiving their qualified immunity. And even in a retaliatory arrest, if there is first probable cause to deal with your arrest, you cannot sue. If they do not have probable cause and they did not exercise officerial discretion to not arrest, then you can sue. Why? Because they've lost qualified immunity. And one more case is Hartman v. Moore, is 547 U.S. 250 2006. One must plead and show the absence of probable cause. And any time you're dealing with the police and you are going to sue them, you must not only speak about the probable cause not being there, but you also have to show their actions were done without probable cause. And we know probable cause only comes from a crime. Now, we also know how to figure that out. We also know the crux of how we need to get those materials. And generally, what happens is whenever you are working to get these things done, I've given you a video that illustrates the first thing you need to do when you are preparing for just this. Not necessarily everything, but when you are building your case for a defense, this is also the time to gather evidence for your lawsuit. And the absence of probable cause is the staple of your lawsuit. So keep in mind, Neves v. Bartlett, 587 U.S. 2019 is only valid if the officer makes an arrest without probable cause. So for right now, that's it. I'll see you next time.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.